Good morning, everyone. We are delighted to welcome you all to the third and final session of our Environmental Rights Training Series. Community Law and Mediation set up the Centre for Environmental Justice to work on bridging the gap between environmental and social justice issues. Ensuring that everyone has an awareness of their environmental rights is a critically important aspect of this, and we especially welcome those joining today who are completely new to the issue. Hopefully, greater knowledge of the Aarhus Convention might provide new insights in thinking about how social justice issues can be addressed holistically. Today, we are discussing the third pillar of the Aarhus Convention, access to justice. When do environmental concerns become a matter of injustice, and who gets to go to court? This training session could hardly be more timely. We're living through a Dáil-declared climate and biodiversity crisis while inequality continues to increase in Ireland. Yet the potential financial risks of bringing environmental cases before the courts remains a live concern, alongside attempts by government to restrict access to justice for environmental NGOs. It is critical that citizens and environmental NGOs are empowered to fight for clean air, water, and a healthy environment, because the environment is unable to speak for itself. There was an interview earlier in the year with Judge Anthony Collins, a judge of the General Court of the European Union, who called for improved access to the courts for activists due to the fact that Ireland has historically displayed, in his words, an astonishing reluctance to comply with EU environmental laws and only seem to pay attention when taken to court. I'm very grateful to be joined here today from France and London by Sophie Bluff and Dr. Andrew Jackson. And I'd like to thank them for generously sharing their time and expertise, and also to thank Community Foundation for Ireland for funding these talks. Just one small piece of housekeeping before we start. We will have a short period of time at the end for Q&A, so if you do have a question, just pop it into the Q&A box. If you see a question similar to one you would like to ask, simply upvote the question with the thumbs up function, and that will make the question more likely to be addressed. As this is a short event, I'll get started. I'd like to introduce our first speaker, Sophie Bluff. Sophie is a disputes lawyer working with DLA Piper UK with an interest in environmental and social justice issues. Thank you very much, Sophie.
Thanks, Rose, and good morning, everyone, and welcome to the final presentation in our series on the Aarhus Convention. And this presentation is on the third pillar, which is access to justice. So just going to do a brief recap before we get into it. So as we now know from the previous two presentations, there are three pillars relating to the Aarhus Convention. The first relates to access to environmental information. The second relates to public participation in the environmental decision-making process. And the third relates to access to environmental justice. So as Nicole and Fred explained in the first session, access to environmental information is a fundamental aspect of the Aarhus Convention. The public should be entitled to access to information about the environment without needing to prove a special interest. The first pillar also covers the need for active dissemination and the importance of transparency of information to the public. The second pillar relates to public participation, and as Tessa and Alan discussed last week, the second pillar regulates public participation in decision-making processes. Depending on the activity requiring public participation, there is a distinction between the public and the public concerned. So the public concerned was for decisions in specific activities, whereas the public at large concerns wider plans, programs, and policies relating to the environment. We also discussed how the public can participate in numerous ways, such as surveys, public consultations, etc. So access to environmental justice. So there are four key aspects to access to justice. So the first is that the key cornerstone of the third pillar is to ensure that the first two pillars are upheld. And access to justice is enshrined within Article 9 of the Aarhus Convention, as well as being a fundamental right across law and legal aspects. So bearing the first pillar in mind, which is access to environmental information, the Convention ensures that any person who believes that their request for environmental information has been either wrongly refused or inadequately answered should have access to a court or tribunal or independent body established by law to review the procedure. With regards to the second pillar, public participation, the Convention ensures that any affected members of the public should be able to review the substantive and procedural legality of any decisions that were made within the scope of Article 6 of the Convention which relates to those members of the public concerned. The Convention permits this right, provided the public either has a sufficient interest or can claim an impairment of right. And I'll discuss what sufficient interest and what impairment of right means later on in the presentation. The third section is in Article 9.3, and this relates to breach of environmental law more generally. So as we know, environmental law has a broad scope of protection. It doesn't relate just to individuals, but everyone in the environment. So this section of the pillar ensures that members of the public have access to administrative or judicial procedures to challenge acts or omissions by individuals or public authorities which breach national environmental law. And finally, underpinning all of these three is the obligation that judicial access to justice should be fair, equitable, timely, and not prohibitively expensive. So by fair, this means that the remedies granted by review bodies should be adequate and effective, which includes injunctions where necessary. And injunctions are things that force someone to do something or forces someone to stop doing something. To be fair, the decision and procedure must also be impartial, free from prejudice, and apply equally to all persons. The public should also be informed about the review procedure and the outcome of the review. To be equitable, the law should not be applied in an unnecessarily harsh and technical manner. And timely depends on the complexity of the matter and varies as to whether you're looking at the first pillar or the second pillar or a breach of environmental law more generally. In relation to access to environmental information, often time is of the essence here. So it's deemed that any review procedure should be done quite quickly. But having said that, as access to environmental information is normally fairly straightforward, it's a request that needs to be reviewed. Previous guidance have said that it should be completed within 15 days or 30 days, depending on the kind of complexity of the request. In relation to public participation and breach of environmental law more generally, this really depends on how complex the issue or matter is that's being reviewed. However, if, for example, an injunction is involved, these are often done on an urgent basis and therefore should be done quite quickly. And finally, prohibitively expensive. So this ensures that any member of the public is not put off seeking judicial remedies by virtue of the costs involved. So the costs incurred by the applicant must be considered as a whole, taking various factors into account. And some of these factors include either the individual situation of the applicant and also whether environmental justice is considered more or less expensive than other forms of justice. So that's what the third pillar is. So now I'm going to quickly look at where it is found. It's obviously found within the Convention in Article 9. And then in Ireland, as we kind of previously discussed, there's a patchwork of legislation that covers the House Convention. But a key one is the Environment Miscellaneous Provisions Act 2011. And this seeks to minimise costs in relating to seeking judicial review or other remedies. So that's bearing in mind the need for no access to be prohibitively expensive. Here, each party needs to bear their own costs, which differs from the kind of usual concept that the loser pays. And it is also possible to apply to the court before or during proceedings for determination that cost protection will apply, which will give the applicant some peace of mind. And also, the Act holds that judges must consider the House Convention where applicable, which therefore ensures that justice remains fair and equitable. In the UK, access to justice is actually enshrined in the civil procedure rules, rule 45.1 to 45.46, if anyone fancies some bedtime reading. And this covers protective costs orders. And these cap the liability of one party, usually the claimant or applicant, to pay the cost of the defendant if the claimant proves unsuccessful. The defendant can also cap their own liability if they are unsuccessful in defending a claim, but the cost cap is usually higher than if it were for a claimant. And this limits the financial burden of the parties, again, thereby ensuring that nothing is prohibitively expensive. Also on the UK, and I will touch on this, later on in the presentation, but usually a claim is brought by judicial review. And there's been a lot of talk in the UK about how difficult judicial review is, how expensive it is. And so the government is putting forward plans to reform the judicial review process, which at least in the UK may help improve access to justice under the Aarhus Convention. So we're just going to do a quick poll just to pep everyone up on a Wednesday. So we've looked at what the pillar is and where it is. So we're just going to quickly test your knowledge to see if you can work out when will the third pillar apply. So I've got 3 examples here, and I'll read them out, and then at the end there'll be a quick poll, and you can pick whether the third pillar will apply in each of these scenarios. So the first one is the city administration of a town has issued permission for the construction of a facility but has not carried out a proper environmental impact assessment. The only available information was a short article about the decision in the local paper. The second situation is Wasteco is 50 kilometres away from a town, but dumps its waste products in the river that flows through the town. And the mayor is concerned about the growing sickness rate. The mayor learns that the regional authorities know that Wasteco have violated the terms of various permissions granted to them, but have taken no steps to do anything. The town administration sues Wasteco on the grounds they have violated their permissions. And finally, an environmental NGO has sent a letter to the Minister of Environment in which the desire is expressed to participate in the development of a plan for recycling of waste in the country. The ministry has not answered the NGO's letter. So hopefully, so if you would just like to choose 1, 2, or 3 as to whether the third pillar, access to justice, will apply in each of these scenarios. It's multiple choice, so hopefully you can choose between all 3 of them. I'll just give you a couple of minutes to decide. Okay, I think we've got, yeah. Okay, great. So as we can see, we've got most people think that at least it will apply in each scenario. The most popular one is choice 1. So I'll just go through each of these. So yes, access to justice will apply in the first scenario. The public have not been informed about the project. So the right for participation in decision-making has not been secured, and therefore the public has not had an opportunity to comment on the decision to build the facility. And this is in breach of Article 6 of the Aarhus Convention, which we know relates to public participation. So yes, the third pillar will apply here. The third pillar will also apply in the second scenario. As Wasteco are breaching the terms of the permission, they have therefore violated the legislation on protection of the environment. So again, this is a breach of the third section of the pillar, which I showed you on the first slide. And it is worth noting that activities or emissions by private persons and organisations who breach environmental laws are also subject to this pillar. It's not just public bodies. And the third one, which was the least popular choice from recollection, The third pillar does also apply in this scenario. So third pillar applies to all three. So in relation to this scenario, the right to access of information has been violated. Even if the NGO wasn't able to participate in the process for whatever reason, the ministry should still have presented information about the process and answered the NGO's letter. Okay, so who can obtain access to justice? So in relation to environmental information, as you will remember, Article 9.1 provides that any person who believes that their request for information has either been wrongly refused or inadequately investigated should have access through a review procedure. So in this instance, the person who applied for the information is able to bring the review procedure. In relation to public participation, members of the public should have access through a review procedure to challenge the substantial and procedural legality of decisions. In decisions on specific activities, this right is granted to members of the public concerned who have a sufficient interest or an impairment of right. What constitutes sufficient interest or an impairment of right is actually a matter of national law, and is usually assessed when an application for either judicial review or other claim is made before the court. However, it is important to note that NGOs who are active in environmental protection have already been recognised by the Aarhus Convention as having sufficient interest. So an NGO would automatically be able to obtain access to justice here. And it was also important to note that whilst what is sufficient interest of right is a matter of national law, the national law must be construed as part of the Convention's aim to give access to justice to the wider public. So it's important to bear a court should bear that in mind when deciding that. And finally, for national environmental legislation, members of the public who want to challenge breaches of national environmental legislation can bring a claim. The Convention does make it optional for member states to impose national criteria for members of the public when bringing a claim for national environmental legislation breach. It's optional, and any national criteria should still ensure the Convention's aim of having wide access to justice, so it can't be too narrow. So who has potential access to justice? So there are four groups of people on the slide. What I'd like you to do is decide who has potential access to justice. So hopefully another poll will appear, and you can again tick multiple options. So you've got Adam, who made a request for information to the Ministry of the Environment, Greenpeace, local residents to a new planned sewer works, and Mrs. A. Sorry, my just give you a couple more, a little bit more time to pick. Okay, I think, yeah, great. So yeah, pretty much all of you got it, and it's a bit of a trick question because all of them have potential access to justice. So yes, you're right. Adam, who had his request for the information to the Ministry of Environment, would definitely have access to justice. Greenpeace, as an NGO, we've already discussed, has sufficient interest. Local residents to a new planned sewer works may have access to justice if they weren't properly properly able to participate in the decision making. And Mrs. A. Smith, as a member of the public, may want to claim for a breach of national environmental legislation. So we've discussed the what, the when, where. So how does one make a claim under the Our House Convention? So the procedure is kind of similar both within the UK and Ireland. So the first one I'm going to discuss is judicial review. And this is the most common method for accessing justice under the Our House Convention, as it means a judge will review the lawfulness of a decision or action made by a public body. It is important to note that the judicial review, the court is concerned with how the decision was made rather than the decision itself. So if a judicial review application is successful, one of the remedies is for the decision to be quashed, meaning that the process has to be retaken. So for judicial review, it's actually a two-step process. So you need permission from the court first in order to launch a judicial review application. So I put on the slide, act quickly. Ideally, you need to make an application for a judicial review within 3 months of the underlying matter happening. And there are several grounds for judicial review. So there's illegality, irrationality, or unreasonableness. This is actually quite a high bar for a ground for judicial review. And it's normally that the decision must be so outrageous that no sensible person could have arrived at it. And it is very difficult to bring a decision for judicial review on this ground. The third one is procedural impropriety. And this is described as the rule against bias and the right to be heard. So normally a flawed consultation process and restricting a right to be heard is a common ground for judicial review. So it's very common within public participation judicial reviews. And it's, the idea that any authority must act fairly and without bias. There's also a breach of legitimate expectation. So someone has been given the idea that they can legitimately expect a certain result and it doesn't happen. That's another ground, and also a breach of human rights, which is considered a new ground for judicial review. The remedies, as I briefly mentioned, so you can get a mandatory order, which requires somebody as in a public body or an individual, to do something, a prohibitory order, which restrains or prevents a body or an individual from doing something, and a quashing order, so to set aside the decision of a body on the basis that it is invalid. The other option is actually a private nuisance claim. So this is usually caused by a person doing something on their land, which they are entitled to do, but it comes a nuisance when it extends to the land of their neighbour by causing damage. Damage is not always an essential requirement, and the concept of damage is quite fluid. So we're thinking here a waste sewer work that suddenly starts, spewing waste to a neighbour's land or something like that. So there are three types. So there's encroachment, so something impedes on the neighbour's land, direct physical injury, or interference with quiet enjoyment of a neighbour's land. So things like noise, increased traffic, etc. So the nuisance must be substantial and reasonable. It can be a single incident or a state of affairs, so something's going on for a sustained period of time. And it can also be caused by either failing to do something or taking a positive action. And the remedies involved are, again, an injunction. So you can have similarly a prohibitory or a mandatory one. And there's also something called a quia timet, which prevents harm occurring. And then there's also damages. So this would put the claimant in the position they would have been had the nuisance occurred as far as possible. So in private nuisance, it normally relates to the value in the claimant's land has been reduced. So you would receive damages to kind of top you back up to where it used to be. We will discuss private nuisance and the Our House Convention in the context of a case study, because there are some limiting factors to private nuisance claims. So just briefly, kind of access to justice in practice. There is something called the Aarhus Convention Compliance Committee, which is called the catchy ACCC for short. And it's quite unique in environmental law as it allows members of the public to communicate concerns directly to a committee of legal experts. And whilst the ACCC cannot make binding decisions, it can make recommendations which are usually followed. So it ensures compliance with the convention. So a party, i.e. a member state, can submit to the ACC on its own. Another member state can dob in, for want of a better word, another party on their compliance with the convention. The convention secretariat can make a referral, or a member of the public may make what's called a communication concerning the compliance of the party. So if you dig in and read up on case law related to the Aarhus Convention, you'll often see cases have the reference ACCC / a couple of digits. And this means that the case was actually heard before the ACCC rather than a established kind of UK or Irish court. And then on the Aarhus Convention as a whole, in 2018, the European Commission, actually carried out an impact assessment on the implementation of the Aarhus Convention in relation to access to justice. The ACCC had been complaining to the EU that the EU had actually failed to comply fully with the access to justice point due to increased cost in justice, the difficulty in bringing things like judicial reviews, etc. And actually this year it was informally agreed that the Aarhus regulation should be revised in an attempt to limit further the costs of NGOs, bring more matters under the scope of the ACCC, of the convention, sorry. I should state that it was an informal agreement, so nothing has been set in stone. It hasn't been kind of formally sanctioned by members, by the EU, and then nor has it filtered down to member states yet. But just something to be aware of, that it's not all rosy, and it has at least been acknowledged very high up that it does need to be amended. But whether it will is, of course, another matter entirely. So just before I finish, we're just going to have a quick look at some case law examples. So the first one, I'm sure many of you will be familiar with Belfast City Airport. So in 2008, a planning application was submitted to extend the George Best Belfast City Airport runway by 590 metres. And in August 2008, the Cultural Residents Association referred the matter to the ACCC, claiming that the UK had breached Articles 3, 7 and 9 of the Aarhus Convention. The UK had made the decision to expand Belfast Airport by way of a private planning agreement, which was only enforceable between the contracting parties. So the CRA claimed that the UK had breached the requirement for public participation by making the decision by virtue of the private planning agreement. The CRA also claimed that their access to justice to challenge the procedure was impeded due to the prohibitive expense in bringing the application to judicial review and challenging the decision. The CRA also alleged that there was a further breach of the convention, as there was no clear, transparent and consistent framework in order to implement the convention. The ACC actually found that there had been no breach of Article 3 and Article 6 due to the length of the runway. So because it was only 590 metres, it fell just short of a list of decisions that kind of in relation to airport runways under the convention. However, it did find that there had been a breach of Article 9 and that the costs were prohibitively expensive. The ACC ruled that reference to fair costs should be in respect of the claimant, not in respect of the defendant public body, which obviously here was the UK, so slightly bigger pockets. And then finally, this is in relation to private nuisance claims. So in Austin and Miller Argent, South Wales, Miller was operating an open cast coal mine as part of a land reclamation project. They had to put in place effective noise and dust suppression measures as a condition for operating the site. Austin lived close to the site and claimed that she was affected by dust and noise. And the Court of Appeal held that a private nuisance claim, which had a close link to the environmental matters regulated by the Aarhus Convention, and which, if successful, would confer a significant public environmental benefit, was in principle capable of attracting a protective costs order. The court also held that private nuisance actions were capable of constituting procedures which fell under the scope of Article 9.3, so that was breach of environmental legislation, and ensures that members of the public have access to administrative or judicial procedures to challenge these acts and omissions. However, there still does need to be a significant public interest in the action to justify things like the special cost procedure, which would therefore make it not prohibitively expensive. And also the nature of the complaint had to have a close link to the particular environmental matters regulated by the convention. So just before I hand over to Andrew, so Aarhus Convention, access to justice. Access to justice is essential in the implementation of the Aarhus Convention. It is important as it allows members of the public to challenge information requests, public participation decisions, and ensures that justice is accessible, fair, transparent, and inexpensive. New reform, which is, as I've mentioned, being at least discussed, should make it hopefully easier to obtain access to justice. However, this is still in the hypothetical stages at the moment. And also, the third pillar is really important as it helps maintain trust in public law and authorities and institutions as they can be held to account. So that's it for me. So I will now hand over to Andrew.
Thank you very much, Sophie, and thanks for such a comprehensive overview of the access to justice provisions of the Aarhus Convention. And I think that last point, again, the importance to maintain trust in public law and authorities and institutions is a really important one to make. And I imagine that point about how access to justice should be accessible and inexpensive might raise a few eyebrows amongst those attending, because I think many would feel that access to justice in Ireland isn't accessible or inexpensive. And so I would encourage anyone attending, if you have any questions, please do pop them in the Q&A box, because we will have time at the end to deal with them. I'm going to hand you over now to Dr. Andrew Jackson, who's an assistant professor in UCD and a practicing solicitor in the area of environmental law, and acted in the well-known Climate Case Ireland case, which appeared before the Supreme Court last year. Andrew, thank you very much.
Thanks, Rose, and thanks everyone. So I'll just dive straight in. The first thing I wanted to touch on was the particular importance of access to justice at the national level within member states of the EU in the field of environmental law. And the point I want to make here is that traditionally enforcement of environmental law within EU member states has relied quite heavily on the European Commission taking action against recalcitrant member states. But over the past years, in particular since the financial crisis in 2008, the European Commission has gradually reduced its enforcement activity. And you can see that in particular here from 2008 to 2019. This is the open environmental infringement cases that the European Commission has on its books against member states. There's an interesting uptick in 2020 that you can see there. But the number of open cases doesn't tell the full story, as we'll see. And of course, if the European Commission is less active in enforcing environmental law, which is an area that's very much dominated by EU law within Ireland, of course, then the slack has to be picked up at the national level by the public and by NGOs and so on accessing justice, if the rule of law is to be vindicated. Now, as I said, open cases, the cases that the Commission has on its books don't tell the whole story. this graph shows the number of cases that the Commission is actually referring to the Court of Justice. In other words, pushing a case beyond just the infringement proceedings, the exchange of letters with governments, actually pushing a case all the way to the court. And you can see from a high of about 60 environmental cases a year in the mid-2000s being referred by the Commission to the Court of Justice, that has tumbled right down to about 10 cases a year around 2016. And an equally interesting image to consider is this one. The solid line shows the environmental cases reaching the Court of Justice in Luxembourg, and the solid line shows the Commission's share of those cases. In other words, cases that are before the Court of Justice because the European Commission has taken a country to the court. And you can see from a high of more than 8% of the cases, the environmental cases being handled by the Court of Justice, being as a result of European Commission-led infringement action, that percentage share has tumbled down to about 20% today. And the gap is made up of cases that reach the court in Luxembourg by way of preliminary reference. In other words, members of the public, NGOs and so on, taking action at the national level and then persuading the national court that there's a point of interpretation that needs to be determined by the Court of Justice. So the dynamic is fundamentally changed within environmental law. The European Commission has reduced its activity, putting much greater pressure on access to justice at the national level. There's a really good article on all of this that I'd recommend. I've put the full reference at the bottom if anyone's interested in it. You can see it there by Andreas Hoffmann. And essentially the argument is this, and those graphs that I've shown are from Hoffmann's paper. He says the European Commission, in light of this dynamic, in light of the fact that it's not in a position politically and otherwise to exercise its traditional enforcement function, the Commission has spent quite a bit of effort on trying to liberalize access to justice at the national level. In other words, outsource the enforcement function to NGOs and the public. But as Andreas Hoffmann says, private enforcement of EU environmental law is dependent on what he calls national opportunity structures, which are unlikely to ever be fully liberalized and harmonized by EU law. And therefore, private enforcement, in other words, access to justice at the national level, is not a panacea for environmental compliance problems, and the growing absence of a central enforcing authority like the European Commission is a concern. I've underlined the word national opportunity structures because really that's what I'm going to talk about now. These are the levers of control that governments have to either make it easier for people to go to court at the national level or make it more difficult. And as Hoffmann argues, those levers have not been effectively harmonized at EU level. Member states still have a good degree of control over those levers, as we'll see. So Sophie's already spoken about design, and the particular part of the Aarhus Convention, the particular part I want to focus on today is the not prohibitively expensive bit, which has been one of the trickiest things in Irish terms, and indeed in the UK, this requirement that access to justice must not be prohibitively expensive. Important context here is that EU law has failed to implement this provision systematically. So the European Commission tried to introduce a directive on access to justice, a horizontal directive that would harmonize access to justice in environmental matters in 2003. And that was rejected by the member states. They simply refused to negotiate and agree that directive. So we don't have a kind of horizontal treatment of access to justice at EU level. And instead, what's happened is the European Commission has managed to get standalone access to justice provisions into certain instruments of EU law. I'm not going to go through the detail here. I've just given you a list of some of the provisions. The important message is there is no horizontal directive covering all areas of environmental law. Instead, you have this piecemeal treatment where, for example, if you look in the Environmental Impact Assessment Directive, you'll find there's an access to justice provision saying, member states must provide access to justice in respect of decisions covered by that directive, and access to justice must not be prohibitively expensive in that area. Now, what that has done is created an opportunity for recalcitrant EU member states to say, okay, well, in providing access to justice at the national level, we're not going to do something that covers all of environmental law. We're just going to do the narrow thing that's required of us by EU law and introduce access to justice in respect of these individual instruments of EU law. Now, the Court of Justice has stepped into the breach and filled in the gaps somewhat, as we'll see, by progressive judgments, sort of expanding the scope of coverage of access to justice insofar as EU environmental law is concerned. But nevertheless, that dynamic is there, no horizontal directive and sort of piecemeal treatment. Okay, that's all by way of background to the position in Ireland and the problem of prohibitive expense in Ireland. As many or most of you will know, when it comes to environmental litigation, thinking about, am I going to litigate a particular case, key thing to consider, or a key thing that a client will of course want to consider is, well, is this going to ruin me? Is it going to bankrupt me if I do this? What's my financial position going to be at the end of this? Can I even afford to go into this at all? And there's two central aspects you need to consider. You of course need to think about your own legal team's fees and outlays. And I mention the outlays because those are not insignificant in litigation. Photocopying costs, taxis, couriers, all these kinds of things can come to thousands and thousands of euro in a case, particularly a case that goes on appeal to maybe the Court of Appeal and or the Supreme Court. So you need to think about your own lawyer's fees and outlays. You also need to think, of course, in a loser pays system about your opponent's legal fees and outlays, because the standard rule of civil litigation being loser pays. If I take the case and lose, well, I might be on the hook for a lot of money, as we'll see. And this has historically, traditionally been a big problem, this problem of prohibitive expense. I'm just going to give you, don't worry about the detailed examples of the sorts of costs that we're talking about. The first is particularly high, but as we'll see, when I move to a more standard case, the costs are still very high. So this was a case where the legal fees ended up being disputed before the taxing master. A case taken by a residents' association against On Board Pleanála and the Attorney General. And the applicant, the residents' association, won, and costs were awarded to them. And you get a sense of the fees that were awarded here after the taxation. Brief fee of 60,000 for senior counsel, 40,000 for the junior, 4,000 a day in court for the senior, and nearly 3 a day for the junior. The taxing master allowed all of those fees and reduced the solicitor's instruction fee from 325,000 down to 225,000. Now, as Garrett Simons, now a judge of the High Court, commented, these were complex proceedings, heard for 8 days in the commercial list. So you might think, okay, well, that's an outlier. These are very high fees. But in the same paper, Garrett Simons immediately goes on to consider what he calls a common or garden action for judicial review. In other words, a kind of paradigmatic case. This is the run-of-the-mill example. And that was a case in which an individual, Mr. Clone, a farmer, ended up liable to almost 120,000 euros for losing a case in the High Court against On Board Pleanála. And that case ended up on preliminary reference before the Court of Justice, and that the decision is to do with prohibitive expense. But you get the picture, in a loser pays system where going in that you might be on the hook, even if you only argue your case in the High Court for maybe 120,000 euros, that's going to severely restrict the potential pool of litigants. People are just going to think, well, This is a really important issue, but we simply, if I'm an individual, I simply can't afford it. If I'm an organization, well, the board of directors simply can't approve this action or whatever. And by way of context, in practice, there is no legal aid for environmental cases. So just to give you a picture in your head then, and to sort of pull the threads together for a moment, at the top level, you have Article 9 of the Aarhus Convention, which filters down through EU law to Irish law. As I described, there's no horizontal directive on access to justice. There are individual access to justice provisions in some instruments of EU law. And what Ireland appears to have done back in the day in 2010, 2011, when these two legal provisions that I have on the slide at the bottom were introduced, was not to tackle access to justice in environmental matters in a broad horizontal manner, but rather it seems attempted to do the narrow thing pursuant to EU law, of picking out the different instruments of EU environmental law that would require access to justice to be provided at the national level. Now, you could immediately say, well, that seems to be in breach of the Aarhus Convention, because the Aarhus Convention doesn't say you only need to provide access to justice in respect of the Environmental Impact Assessment Directive, et cetera, et cetera. It simply doesn't do that. And that is true, and there are complaints ongoing to do with this whole area before the Aarhus Convention Compliance Committee. But what these two provisions did then, so Section 50B of the Planning Act 2000 and the Environment Miscellaneous Provisions Act 2011, they overturned the standard loser pays rule. And this is really interesting if you're from a field outside environmental law. This is a really good example, I think, of how it is possible to be quite clever with cost rules to liberalize access to justice. So what has happened is the loser pays rule no longer applies in certain types of environmental and planning cases. And instead, we have a system of so-called one-way cost shifting. And there are two limbs to this. The first is each side goes into the case knowing that they're only going to have to bear their own costs as a first principle. So I know if I fall within these special rules, I'm not going to have to pay the other side's costs if I lose. So that's a good starting point, but my own legal costs may still be prohibitively expensive. So the second limb of the Irish rule is that the court has discretion to award a winning applicant only, not the other side, only the applicant side, its costs or part of its costs to the extent that the applicant is successful. Now, both limbs of that are really important. The second limb is particularly important because it allows applicants to find lawyers who are willing to take cases on a conditional fee basis. In other words, on a no-win, no-fee basis. So you can find if you've got a case that looks like it has, let's say, a reasonable prospect of success, you may be able to find solicitor and barristers who will take the case and say, look, you don't have to pay me up front, but if we win, then I expect that the court will exercise its discretion to award you your costs, and therefore we will get paid. So, it's a system that effectively liberalizes access to justice, but the real difficulty that we've seen has been the scope of application of the rules, the uncertainty as to when these special cost rules apply. But as I say at the bottom here, the result has been much improved access to justice in Ireland, but we've seen about 10 years of satellite litigation arguing over the scope of coverage of these cost rules, because that has been quite uncertain. But the end result is if an applicant certainly falls within these rules, it may be possible to take a case knowing that your financial risk is limited to court fees, stamp duty, and so on, and outlay costs, rather than all the massive sort of legal fees that I have described. But the problem, as I said, uncertainty, and I'll give you one example here of a case I was involved in a few years ago. This was a challenge to Edenderry peat-fired power stations re-permitting, applied to get re-permitted. And at that time, if you looked at the relevant statutory provision, it seemed to provide for the special cost rules to apply where a challenge was based on the Environmental Impact Assessment Directive, because that directive is specifically mentioned in section 50B of the Act. But it didn't seem to provide or cost protection for challenges based on the Habitats Directive, another instrument of EU environmental law. And even although this legal challenge clearly raised issues under both directives, in this challenge before the High Court, An Taisce limited its arguments to the Environmental Impact Assessment Directive and excluded arguments relating to the Habitats Directive because it didn't want to take the risk of the court at the end saying, okay, well, An Taisce in fact won this case, but had they lost, they didn't want to run the risk of the court saying, well, you spent 50% of your time in court arguing about the Habitats Directive and 50% arguing about the EIA Directive. So we're going to say that you're protected from costs for half of the time you spent in court, but the Habitats Directive arguments were not cost protected, and therefore you're on the hook for half the respondent's legal bill, let's say. So the result of the uncertainty is a kind of distortion, or has been a distortion of the types of legal points that are taken. So over the last 10 years, there's been a lot of argument about what is the proper scope of coverage pursuant to international law, pursuant to EU law, and so on. And to cut a very long story short, essentially, we finally reached a position where the cards have fallen in favor of a broad application of access to justice rules and cost protection in environmental and planning law in Ireland. As a result, there are lots of cases, by two in particular I'll mention here. One before the Court of Justice, and this was an Irish preliminary reference case to do with the grid and pylons. And essentially what happened here was the Court of Justice applied a very broad interpretation of Article 9.3 of the Aarhus Convention in EU law. They said, where the application of national environmental law is at issue in a case, it's for the national court to give an interpretation of national procedural law, in other words, for example, the cost rules, which to the fullest extent possible is consistent with the objectives laid down in Article 9 of the Aarhus Convention, so that judicial procedures are not prohibitively expensive. So in other words, that's an instruction to national courts saying, look, whatever games your national governments have played in terms of trying to, pick and choose which instruments of EU law will be protected from cost, et cetera, we're giving you an obligation of interpretation to interpret your national rules insofar as you can to provide for access to justice in a way that's not prohibitively expensive. And the second case is one called Heather Hill. It's a case before the High Court against Bord Pleanála, which Bord Pleanála has appealed to the Court of Appeal, which essentially provides for a very broad application of these special cost protection rules in respect of planning permission decisions. So we've reached an end point after 10 years of litigation around the scope of application of these special rules that has resulted in a broad scope of application. So, litigants now thinking about taking environmental cases in Ireland, more so now than 10 years ago, would have a good chance of being advised, yes, we think that, you are cost protected in taking this particular case. You should be able to find a legal team who'll do it on a conditional fee basis, et cetera, et cetera. But there's an ongoing tension. I'm going to speed up now so we have hopefully a little bit of time for questions. There's an ongoing tension between Irish policy and law on the one hand, which has traditionally tended or trended towards making it more difficult for the public and NGOs to challenge land use decisions in court, and international law, the Aarhus Convention, and EU law on the other hand, which have pulled in the other direction, trying to make it easier to access justice. And I'll skip over this. This is just two quotes from the courts, making it very clear that that is an actual policy choice. You can see from the first one here, it's clear the intention of the legislature was greatly to confine the opportunity of persons to impugn by way of judicial review decisions, made by planning authorities. And to finish up then, what we saw at the very end of the last government's term, and it's a story that goes in waves, because we've had 10 years of satellite litigation that's ultimately resulted in this liberalisation of the access to justice and cost rules in a way that provides greater access to justice for the public and NGOs. And almost in response, we now see proposals to look at those rules. What can we change about them to restrict access to justice, to turn the tap down a bit, to make it a bit more difficult for people to bring cases? So at the end of the last government in late 2019, there were lots of changes proposed. I'm just looking at the costs part of these proposals. A new cost regime was proposed for planning land use cases, getting rid of the special system that I've just described, the one-way cost shifting system, and instead proposing to introduce a system of reciprocal cost capping, the system that exists in the UK essentially, under which an individual would know going into a case that they faced a maximum exposure of about €5,000 if they took a case and lost. And for NGOs, it'd be 10,000. Now that would be at first instance in the High Court. And of course, the cost would increase as you go up Court of Appeal and Supreme Court. And the reciprocal side of the cap is if the applicant wins their case, the maximum they could recover was proposed to be 40,000, which might sound like a lot, but to be shared between the solicitor and barristers, the full legal team, that would likely have the effect of restricting the pool of lawyers willing to do cases for applicants on a conditional fee basis, because they may think, well, I'm taking a bit of a punt with this case anyway. I could just do work on a normal market basis for a client rather than for a client paying full whack in the normal way, rather than taking a case that may last a long time, a lot of work, and then find that in fact my ability to get paid is restricted by this cap. And the proposal was that the court would be able to vary these amounts or remove the caps altogether, provided always that it wasn't prohibitively expensive. But the risk of those caps being removed altogether would undoubtedly likely put some people off litigating. So essentially then, the previous government proposed replacing the relatively good cost system that we'd finally ended up with this reciprocal cost capping system copied from the UK, which is known to provide less effective access to justice than the system that we have. And this is the Lord Justice Jackson in the UK in his 2009 report looking at cost rules in civil litigation, and said, having considered the competing arguments, I'm quite satisfied that qualified one-way cost shifting, in other words, the system that Ireland has now, is the right way forward. Now, the UK government ignored that and introduced a more restrictive system in the form of reciprocal cost capping. The aim of all of these proposed changes under the previous government was, evidently to reduce the number of cases, environmental cases being taken by the public and NGOs. And the question under Aarhus and under EU law is, well, are they then going to be providing wide access to justice? Probably not, I think. The argument has not died, and this is where I'll finish. Because the outgoing government is, of course, in power now in coalition with Fine Gael in coalition with the Green Party and Fianna Fáil. The programme for government contains this kind of uneasy compromise statement that the government will review and reform the judicial review process while always adhering to obligations under the Aarhus Convention. So it's a question of watch this space, and the kite flying that has been done. This is a newspaper headline from July, is that the idea born under the previous government has not gone away of making it more financially risky for the public and NGOs to take environmental cases as a way of discouraging those cases being taken at all. But the proposals remain to be seen. So as I say, it's a matter of watch this space. Thanks very much, everyone.
Thank you very much, Andrew. And I think that's an interesting point to end on, that narrative that seems to have been around for a while, and certainly in the media and with government, that environmental cases are anti-development, anti-progress and NIMBYist by nature. So we don't have a huge amount of time for questions and answers, so I'm going to jump right in there. We have a few in the Q&A box, all of which actually echo some of the questions that I had myself. The first is from Anne, just asking the question, can case law information be accessed? And I presume, Anne, you mean in relation to EU infringement proceedings, Aarhus Convention Compliance Committee decisions, but also decisions of the High Court, Circuit Court, and even perhaps District Court with maybe smaller nuisance actions. I don't know, Andrew, perhaps do you want to take that?
Sure, I can't see the questions on my screen actually, but essentially the question is, where can you access all of these various decisions? Yep. Well, the Irish decisions, courts.ie is a good source for, High Court, Court of Appeal, Supreme Court. The Aarhus Convention Compliance Committee is very transparent in its work, publishes its decisions, but also the exchange of arguments and so on by the parties. The European Court of Justice's website has a great search function for finding judgments and opinions of advocates general and so on. The tricky bit is finding stuff happening at the earlier stages of procedure, public access to litigation documents, either at the national level, written submissions exchanged by parties, and European Commission's decision-making leading up to formal court proceedings. That can be tricky to get hold of for sure.
Thanks, Andrew. Just jumping on to the next question. What is being done about the legality of SLAP suits? So these are a strategic lawsuit against public participation to wear applicants down with cost, time, stress, etc. So either Sophie or Andrew, if you want to jump in.
I haven't had any experience with these kind of suits myself, but kind of in the UK, for example, you do have to behave yourself, for want of a better word. And if one party is found to be deliberately slowing proceedings, deliberately avoiding correspondence, doing these kind of dirty tactics, for want of a better word, if they come to the attention of a judge can really come down hard on that party and, put adverse costs on them, or even strike out their defence, etc. So, refuse it to be heard. So, it's obviously up to the discretion of a judge, but if that kind of behaviour is put for a judge, then they normally have a duty to ensure that everyone behaves themselves, for want of a better word, and can really slap some kind of harsh penalties on those parties.
Thanks, Sophie. Andrew, did you want to add anything there?
Just one thing, that there's a provision of the Irish Convention that's relevant in this area, Article 3, paragraph 8, which says each party shall ensure that persons exercising their rights in conformity with the provisions of this convention shall not be penalised, persecuted or harassed in any way for their involvement. So, clearly that provision could be relevant in the context of SLAP suits, and a complaint could be made to the Aarhus Convention Compliance Committee saying, look, my country, my government is not adequately protecting me for my involvement in trying to, vindicate the rule of law in the field of the environment. And that's a provision actually that has been cited recently in the Irish context in court, in the High Court, where a judge was saying, look, people out there generally need to be aware that they need to be quite careful in terms of public statements and so on, where it appears maybe that pressure is being put on a litigant to take a decision, not to continue pursuing a case, to drop a case and so on. And that was particularly evident in the An Taisce proceedings to do with this cheese factory down in Kilkenny, where, politicians were falling over themselves to say that, there was all sorts of languages. This is traitorous, pursuing these legal proceedings. These proceedings, when An Taisce was thinking about, would it appeal to the Court of Appeal, Supreme Court, being implored by politicians not to appeal and this kind of thing. And certainly that treads pretty firmly into Article 3.8 territory, I think.
Thanks, Andrew. Just jumping on to the next question. This is for you, Andrew. Is there a potential under Aarhus to take a case against a department or local authority where the structure or methodology for public participation in effect does not allow meaningful participation. For example, where the system provided for public participation is managed in such a manner so as not to allow PPNs, NGOs, individuals to realise independent and meaningful participation in strategic policy making. This actually came up in our webinar to some extent last week, this feeling by NGOs and others that, you know, there's all these consultations, public participations about, but that essentially it can feel like a tick box mechanism, and that perhaps views aren't genuinely taken on board. So Andrea, I don't know if you have any view on whether there's a potential for a case around that.
Yeah, I mean, I think it's a very good question. A good place to start would be looking at the Aarhus Convention Implementation Guide produced by the UNECE. It's several hundred pages long, and it attempts to flesh out sort of best practices and give examples of things being done well and not well. That, you know, the tricky thing with public participation is, you know, often what people want in participating is not only to feel that they have been listened to, but to actually have the decision be taken in line with what they said. And of course, if people are saying very divergent things, the decision maker can't take a decision that pleases everyone. That's obvious. But there are, you know, at one extreme, let's say, it can certainly appear sometimes that a consultation exercise is tick box, and really the public's being asked to say for their views, and then they're just not being taken into account. To try to, you know, a good practice that moves along the spectrum would be for, you know, a public authority where it runs a consultation to actually produce a table of responses that it received and its own responses to those consultation responses. Do you know what I mean?
Yeah.
And, you know, where a public authority has gone to those kinds of lengths, it would probably be quite difficult to maintain a winning complaint, let's say, to the Aarhus Convention Compliance Committee. But where the public participation exercise is completely opaque, and, you know, people are asked for their views, and it seems like the decision had been preordained and so on, then yeah, absolutely, it might be possible to make a case, but it's very much fact dependent, of course.
Yeah. Thanks. And just a very specific question next. Can you clarify, is the Habitats Directive covered by special cost provisions now?
Great. I love questions. That's an easy one to answer, because yes, it is. They after years of pressure, the government amended Section 50B of the Planning Act to specifically add Article 6 of the Habitats Directive to the list of provisions that are definitely covered. And subsequent to that, the Heather Hill judgment I mentioned came out, which essentially says that the coverage applies to the decision under challenge, so planning permission decisions, rather than having to look at the grounds of challenge, whether it's the Habitats Directive and so on. But yes, absolutely, Habitats Directive. Article 6, which is the provision relating to assessment, appropriate assessment of plans and projects, challenges raising points in that area are covered by the special rules, yes.
Great, thank you. And I think the final question, or maybe there's one more actually, is from Owen. Due to widespread biodiversity collapse and the evolving science and climate change in Ireland, is there any requirement for judges to upskill in these areas so they can rule in an informed way? And perhaps this is an indirect way of asking around whether we should have a specialised environmental court. I don't know if either of the panelists have a view on that or on the specific question.
I think kind of generally it's obviously important for judges to obviously understand the subject matter. And I know, for example, in the UK, they've recently found that obviously with tech, there's so many technological cases that are now coming before judges in the courts. I think the difficulty is it takes so long to become a judge, and they are often put in specific courts based on the experiences they have when they were a barrister. But it's actually, as this is a fairly new area of law, it may take a while for those really truly knowledgeable, skilled judges to kind of get to the bench, because it does take decades, certainly in the UK, to get there. So it might be a bit of a long game. And certainly I've found in front of UK judges is they do very much try to understand the underlying subject matter. And if you are someone bringing a case, you would really ensure that you had like an expert on how to essentially explain to the judge, this is what it is, and et cetera. So there are ways to get around it, and I definitely think that as more environmental cases grow, that there is a need for an environmental subsection division of the court, but it's going to probably be a long-term goal rather than a quick let's create a court and put some judges in, unfortunately.
Thanks, Sophie. Andrew, do you have any view on either of those points?
Yeah, I don't think there's any formal requirement for judges to upskill and train specifically in the field of environment. That being said, there are, of course, all sorts of opportunities for that. One of the main difficulties being that we have such a low, number of judges per head of capita. Where the judges don't have a whole lot of time, I'd say, to be doing continuing professional development in Ireland. And on the question of, should we have a specialised environmental court? Well, interestingly, whatever you or I think about that question, the government has committed to do that in the programme for government. So the specific commitment is to introduce, to reform the judicial review process so that those reforms come into effect upon the establishment of the Environmental and Planning Law Court. Now, what that will look like is anyone's guess, whether it will be a list of the existing High Court, or will it be, a dedicated court? Who knows? And there are all sorts of different views on whether that is the right thing to do or not. And if the person who asked the question goes looking, you'll find a few years ago at UCC, there were a few papers on this that you'll find online. The Chief Justice Frank Clark wrote a paper on it, I think, and a couple of others. So there's quite a lot of existing thoughts out there in this area.
Thanks, Andrew. And there is a question, I suppose, in the chat box there, and I think we possibly answered it, but it states, in terms of judicial review cases, lower income communities and our native environment appear to be the losers. What advice could I provide to a community who wish to appeal a decision? Well, I think it's perhaps been answered in relation to the special costs rules that Andrew has mentioned, but also to say that Community Law and Mediation have established a Centre for Environmental Justice. We do run monthly legal advice clinics, free legal advice clinics, and our next advice clinic is on the 19th of October. So if you are advising an individual or community group around an environmental issue or an environmental justice issue in particular, please do refer them to that service. And so I'm going to take this opportunity to wrap up, because we've gone over time a little bit, but only because the questions that have been so engaging. So just to remind you, obviously, of that clinic, but also to say that CLM are going to be running environmental justice training sessions soon for community organisations. And if you're interested in that, please do get in touch and we can provide you with more information. I'd also like to thank our speakers, Dr. Andrew Jackson and Sophie Bluff, for joining us from around the world today, and to you all for attending this morning and being so engaged in your discussion and in your questions. So thank you very much and have a lovely morning.